I'd like to call this meeting to order. Today is Tuesday, July 2nd, and 2019. We have a public hearing. It's an appeal of the hearing's official denial of a zone change for Simmons Investment, City File Z19-1. So thank you all for coming, all two of you at this point. Tonight we will be holding a public hearing, like I just said. I won't repeat it. The application was denied by the hearings official, the Eugene hearings official. My name is Kristen Taylor, and I'm the chair of the Eugene Planning Commission. So to start, I'd love the planning commissioners to go around and introduce themselves.
John Borowski.
Stephen Baker.
Chris Ramey.
Lisa Fragola.
Ken Beeson.
And we also have some staff present, and I'll just have you introduce yourselves.
Alyssa Hanson with the Planning Division.
Rodney Bonner with the Planning Division.
Gabe Flock, also with the Planning Division.
Lauren Summers with the City Attorney's Office.
Great, thanks. So now I'm going to enter into my spiel. I'm going to read it to make sure that I don't leave anything out. So I want to explain who the Planning Commission is and what our role is. We are unpaid volunteers appointed by the Eugene City Council to 4-year terms on the commission. We all live and work in Eugene. We directly advise our city council on matters related to land use, and we are also tasked with making certain land use decisions on behalf of the city. We're responsible for upholding the laws of our city and our state, the policies of our city council, and of course, at the same time, we're also responsible to everyone who lives and works in Eugene. We're at-large members, which means we must consider the needs of the community as a whole, as well as the needs of all groups and neighborhoods. We're also human beings, just in case you had a question, which means each one of us has personal views that make us who we are. But as planning commissioners, we're committed to balancing all our needs as a community and making the best decisions we possibly can based on our policies and our laws. We strive to sort through all the evidence and facts presented and carefully review the pertinent land use code criteria to make thoroughly informed decisions as a governing body. This can be tough to do, as you can imagine, and we know not everyone will agree with every decision we make. But we try to make these hard decisions through careful deliberation and to the best of our abilities. The Planning Commission's role in this appeal process is to affirm, reverse, or modify the hearing's official decision. Reverse or modify the hearing's official decision denying the zone change application. Tonight, we will listen to what the applicant and the public has to say. We will not take action tonight, although we may begin deliberations, and we'll talk about that later. We will deliberate and take action on this appeal on July 9th. You are welcome to attend those meetings or to watch them on the city's website. As we proceed tonight, we want the public to know that we will listen carefully and hear your concerns about this appeal. Even though we may not ultimately make the decision you would prefer, know that you will be heard and that we will strive to make the best decision possible. The decision of the Planning Commission on this appeal is a quasi-judicial decision. This means we are legally required to have a certain order of speakers, and there are specific rules or criteria on which we must base our decision. First, we'll begin with a brief presentation by staff and then open the public hearing. If anyone in the audience, and I know there were a few that walked in, would like to speak, please fill out a green form, on the table there. And then just bring it forward to staff here at the table. Once the public hearing is open, speakers will be called in the following order: the applicant and those in support of the application, those with a neutral position, and the appellants and others opposed to the application. Staff response to testimony, and number 5, applicant rebuttal testimony. During this process, the Planning Commission may ask questions of anyone who provides public testimony. The Planning Commission's decision will be the final city decision on this matter. Since we have until July 16th to reach a decision on this application, We will listen to testimony tonight and begin deliberations. Further deliberations and final action will take place, as I said earlier, on July 9th. Any additional appeals filed regarding our final decision will be brought to the State Land Use Board of Appeals. The purpose of tonight's hearing is to receive relevant testimony on the appeal before us. And I want to remind everyone that your testimony must be directed toward the issues identified in the appeal statements and the applicable approval criteria from the Eugene Code. No new evidence can be accepted by the Planning Commission, and we can only accept testimony related to evidence that is already in the record. So what this means is that you should be speaking about, one, the materials and information already presented to the hearings official in the first public hearing process, and two, whether or not you think the hearings official made a mistake based on the approval criteria for the zone change and the evidence she had at the time. I want to remind everyone that the failure to raise an issue with sufficient specificity to allow the Planning Commission and parties to respond will preclude future appeals on that issue. In other words, now's your opportunity to raise any issues as clearly as you can so that the city and other parties can address them. Before we begin, the Eugene Code also requires that planning commissioners disclose any conflict of interest, ex parte contacts, biases, or abstentions. In a quasi-judicial proceeding like this one, the parties are entitled to an impartial or neutral decision maker. To ensure this fair consideration, the Eugene Code and the Planning Commission's rules attempt to limit ex parte contacts or communications between a party and the decision maker outside the public hearing process. Each planning commissioner must disclose and describe the substance of any communication they have had about this application outside the public process. The planning commissioners must also disclose any potential conflict of interest. That is, whether the decision they are about to make could or would result in a personal financial gain to themselves, their business, or a member of their household. Finally, a planning commissioner cannot participate if he or she is biased. That is, for whatever reason, he or she is incapable of rendering an objective decision on this appeal. Do any commissioners have any conflicts of interest or ex parte contacts to disclose? Everybody's nodding their head no. Okay, we'll move forward. Have staff received any challenges to a commissioner's impartiality submitted pursuant to Eugene Code Section 9.7065, subsection 5?
No, we have not received any.
Okay, great. So we're going to move next to staff presentation. We'll have a brief presentation from staff, and I think Rodney Bonner from the planning decision will provide the information about the application.
Thank you. So the application before you is Simmons Investment Zone Change Z19-1. The applicant originally requested a proposal to essentially remove the site review overlay from the subject properties. The subject properties consist of 10 tax lots in the just north of 5th Avenue, as you can see here on the vicinity map. As mentioned, the property is all currently zoned SW Whitaker Special Area Zone with a SR site review overlay, and the applicant requests removal of that overlay. This is the zoning map that was presented to the hearings official. I would note that there is a discrepancy at the corner of 4th Avenue and Charlton Street. A previous zone change modified and changed that zoning of the kind of sliver piece, which is now Special Whitaker with no site review. In addition to requesting that the removal of the overlay, the applicant also disputes that the site review overlay applies to the subject property at all, and additionally sought a determination from the hearings official that it does not apply. The applicant submitted the zone change application in February. The application was deemed complete, public notice went out. The public hearing was held on May 1st, and at the request of a neighbor, the record was requested to stay open. We followed a 777 format where the close of the record was left open for 7 days, an additional 7 days for rebuttals, and then the last 7 days for the applicant's final argument. The hearings official issued their decision on May 31st, and the applicants have filed an appeal in a timely manner. And so we are here today, and the decision, according to Oregon Revised Statute and Eugene Code, is due by July 16th. So with the first appeal issue, the argument appears to argue that the city, when the city adopted its new land use code through the 2001 land use code update process, the ordinance that put that new land use code into effect eliminated the SR site review sub-district overlay, and accordingly eliminated all of the site review overlays that had been previously imposed, and that the new overlay zone adopted through that land use code update process in 2001 has never been applied to the subject property. And based on that argument, the applicant seeks to a determination that the site review was never applied at all. In regards to that, we're really looking at the process for which, how the site review was originally applied, what happened in the 2001 land use code update, and how we got to where we are today. So when the Whitaker Refinement Plan was adopted in 1994, the subject property was zoned MU-W, Whitaker Mixed Use. That occurred through a city-initiated zone change application at the same time as required by the adopted Whitaker Refinement Plan. The city applied the SR site review sub-district overlay to the subject properties. No changes to the Whitaker Refinement Plan have occurred since. Staff agree with the hearing's official findings that, contrary to the applicant's argument, nothing in the language or legislative history of Ordinance 20224 supports the assertion that the 2001 Land Use Code eliminated the application of that site review to the subject property. Again, that site review was applied through a city-initiated zone change. Further, there's no language in that ordinance or in the 2001 Land Use Code that removes or eliminates the site review that had been applied to the subject property in 1994. The 2001 code did not impact the continuation of the site review that applied to those properties and was legislatively attached. The city's actions in 1994 to impose that site review when it implemented the Whitaker Plan, the city's actions in 2001 when it adopted the current land use code update, and the city's legislative intent as reflected in the 2001 and the 2001 land use code update and the city's actions since. And lastly, the city's current overlay zone map all indicate that the property is currently encumbered with a site review overlay. There's also raised in some of the materials is a question of the need and desirability of the site review today. Through the 2001 land use code update, more robust design, call them design standards, were applied to various zonings. However, whether or not the applicant thinks the Whitaker Plan policy that required the site review initially be applied to the subject property should be revised or reevaluated based on those changes is not really relevant to the issue of whether the site review, which was applied in 1994, continues to apply. So ultimately, we agree that the site review continues to apply in agreement with the hearings official's decision. The second appeal issue, assuming whether the site review overlay applies, the appellants assert that the hearings official erred in denying the application to remove the overlay. This argument has two subpoints that are address specific code that are part of the zone change approval criteria. We'll go through both of those. The first one is the second approval criteria, to sum up, that whatever the proposed zone change is remains in conformance with the Metro Plan, and more importantly, in this case, the refinement plan. In event of inconsistencies between these plans, the Metro Plan controls. What's relevant here is the refinement plan, specifically the Whitaker Plan Policy 2. I've written out the policy here for your reference. It's also available in the agenda materials. Regarding the consistency with the adopted Whitaker Plan, staff agreed with the hearings official that the applicant has not established that the proposed zone change to remove the site review is consistent with the Whitaker Plan. Staff note that changes adopted in the Land Use Code update reclassified the Whitaker mixed use from MUW Whitaker mixed use to SW Whitaker Special Area Zone. However, the fact remains that the requirement for the site review overlay zone was implemented and attached to the property by way of a zone change decision in the past. Since then, there's been no formal or explicit action by the city to remove that overlay by way of a zone change to date, and staff agrees with the hearings official that the appellant has not provided any evidence to establish that the removal of the site review overlay zone would be consistent with the Whitaker Plan. In conclusion, staff agrees that the applicant has not established that the site review is no longer necessary for the subject properties, nor has the applicant established that the subject properties will continue to comply with the Whitaker Plan without that site review overlay zone. The second approval criteria for the proposed zone change is consistent with applicable siting requirements set out for the specific zone. In this case, we're looking at the base zone siting requirements. In this case, because this is dealing with the siting requirements for the SW Whitaker Special Area Base Zone, which already exists on the subject properties and is not changing as part of the applicant's request, it does not appear to staff that this approval criteria provides a further basis for denial of the applicant's request. And that concludes my staff presentation.
So I also, Lauren Summers from the City Attorney's Office, she's going to give a brief presentation about new evidence.
Thank you, Chair Taylor. Planning Commission, if you'll bear with me, I just want to cover a couple procedural issues. This is as much for the folks who are participating tonight and the folks who are watching at home as for the planning commissioners, because I know that you have just recently gone through one of these appeal hearings. However, I wanted to remind everyone that because this is an appeal from a decision by the hearings official, there are some limits on what the parties can talk to the Planning Commission about and what the Planning Commission can consider. Ultimately, the Planning Commission needs to look at the appeal issues identified by the applicant. So in this case, there were 2 appeal issues. Look at the hearings official's decision, look at the evidence that was placed before the hearings official, and determine whether the hearings official got it right. If the Planning Commission agrees with the hearings official, then the Planning Commission can affirm her decision. If the Planning Commission disagrees with the hearings official, then you may either modify or reverse her decision. In the course of this appeal, the Planning Commission may only consider evidence that was available to the hearings official. So in other words, Planning Commission may not consider any new evidence that was not presented to the hearings official. Folks speaking or submitting written testimony tonight are free to argue that the hearings official made a mistake, or alternatively argue that she got it right, and may refer to any information that was presented to the hearings official as part of that argument. However, folks who are speaking or submitting written testimony tonight may not present any new evidence to Planning Commission, and that is evidence that was not presented to the hearings official. So new evidence includes things like new photographs, facts, other information that was not available to the hearings official when she made her decision. The Planning Commission is limited to the information that was available to the hearings official. If you begin to, or someone begins to talk about new evidence or submits written evidence, submits written testimony that contains new evidence, the chair may ask you to stop. The other piece is that the Planning Commission can only consider the appeal issues that were raised by the applicant. So if there are portions of the hearings official's decision that the applicant is not appealing, those are not before you, and you may not consider them. And then to the extent that folks who are testifying tonight can point to the particular appeal issue they want to address, and or particular approval criteria that you think the hearings official incorrectly applied, that's always helpful to the Planning Commission. And to the extent that the Planning Commission is presented with new evidence later, staff will be asking you whether or not you wish to reject that evidence, and we would recommend that you do. Thank you.
Thank you. Any other comments by staff? So before we open the public hearing, I want to go over I also want to go over a few procedural items. As I previously mentioned, we have until July 16th to reach a decision on this appeal. The appellant will have 20 minutes to speak and is reserved a 10-minute rebuttal time. And then, as I said, we'll go through if there are any other individuals that want to speak. Did you grab a green, so bring up the green sheet. So, okay. Great, it's coming up, arriving soon. Thank you. Okay, so now that I have that set, I'd like to open up the public hearing of the Eugene Planning Commission. We already went through, got everybody's signature, so so the applicant goes first, and so I'm guessing you've just answered my question. So I'll introduce both of you, and then you divide and
Conquer.
speak as you want. Conquer. Teresa Bischow and Bill Close.
Right.
And if you can, state your name, address. Okay.
Thank you. Again, my name is Teresa Bischow, and I'm here tonight with Bill to present the applicant's appeal issues. The first appeal issue, and I think we'll get set up here. Oh, just up or down, okay. That has already been discussed, which is that the hearings official erred in determining the site review overlay zone was applied to the subject properties. The broad legal framework is, step one, you examine the text and context. Step two is you consider the legislative history and the intent of the elected officials. If needed, if there's a disparity between what you believe was the intent versus the plain reading of the code and the actual text and context, you don't interpret it. Instead, you take corrective action, such as amending the text. In the case of the base zones, step one is several base zones, not all of them, but several of them were actually completely 100% repealed. Concurrently, new base zones were adopted, and there's clear legislative text that supports this. And third, there's a table in the land use code that was adopted in 2001. It's still in the current land use code. And it's a conversion or reclassification of the old base zones to the new base zones. We are not contesting that the property is zoned SW, the special Whitaker mixed-use zone. With regard to the sub-districts, there were several sub-districts in the old code. Like several of the base zones, all of the sub-districts were repealed, all of them. The 2001 land use code concurrently changed its terminology and content of those subdistricts, referred to them for the first time as overlay zones, but did not include a reclassification table. There's nothing in the record of the 2001 ordinance that says if property was zoned site review subdistrict, it is now zoned site review overlay zone. Okay. The 2001 land use code update included expressly applied certain overlay zones to specific properties, but this step was not taken with regard to the site review overlay zone. And in fact, and this evidence is in the record, you might have wondered why we included entire versions of the land use code. It was to ensure that it was in the record that of all the overlay zones established in 2001, all of them were applied to specific properties except site review and planned unit development. The land use code ordinance also did not include the council's adoption of a Eugene zoning map or a Eugene overlay zone map. You might have wondered why we included in the record the 1948 zoning ordinance. What the heck? We went back in time to show you a way it could have been done, where when an ordinance, the land use code is comprehensively updated cover to cover, there's a map that's a vital component of that ordinance. And in this case of the 2001 adoption process, there was no council adoption of either the Eugene zoning map or, if it even existed, an overlay zone map. Since 2001, there have been new zones, overlay zones established. All have expressly been applied to specific properties. All of the adopting ordinances expressly amended the Eugene overlay zone map at the same time. Bill will, following the rest of my presentation, Bill will elaborate upon the points I've just made. I want to jump now to, sorry, I got a little distracted there. Appeal issue number 2. I will jump right on. The hearings official determined that removal of the site review was not consistent with the Whitaker plan, but removal of the site review overlay zone, if it exists, does not change the Whitaker Special Area Zone and its ability to implement the mixed-use plan designation in Whitaker. Removal of site review will not change the allowed uses, densities, or standards. The hearings official on a prior decision by the same property owner immediately north of a portion of one of these properties made the determination that applying site review subdistrict zoning to all property zoned mixed-use Whitaker mixed-use is policy 2 in the Whitaker plan. I've done an excerpt there. But the hearings official determined policy 2 is a specific directive to the city to apply site review to a former old repealed mixed-use Whitaker mixed-use zone. Okay, it's not the same zone. That's the determination the hearings official made on a previous zone change. Policy 2 does not require that the site review overlay be applied to the new, and I'm inserting the word new, SW Whitaker Special Area Zone. And I'm just going to run through these briefly. You have the written material before you. These are examples of some of the differences between the old Whitaker mixed-use zone and the new Whitaker mixed-use zone. Several uses were permitted outright. Daycare, residential treatment center, clinics. The new Whitaker Special Area Zone has limitations. A large clinic over 10,000 square feet is required to go through a conditional use permit. It's a different zoning district. It's not the same. The old MUW zone did not list any uses subject to site review because they were all concurrently being rezoned with the site review subdistrict. The new SW zone says specifically lists certain uses that are required to go through site review. Why would that be the case if they all have to go through site review? Anyway. The standards are also different, and we've provided examples. Again, these are just examples to give you an idea. Some of the bigger ones, the old MUW zone, there was no maximum residential density. The new zone does have a density, and it's the same as R4. The site review subdistrict is substantially different than the site review overlay zone. Again, we've listed here, one of the biggest examples was the city council adopted a threshold of when site review would be triggered for the Whitaker mixed-use MUW zone properties. And a new single-family home was specifically exempted entirely from needing to go through site review. That's not the case today. In 2001, the site review overlay requires any new building. There's no exception if you own a single-family home and it burns down. In Whitaker, those homeowners have to go through site review, which is very expensive and time-consuming. I don't believe they understand the burden that they have with the new 2001 site review zoning overlay. The other thing we're seeing I won't go there. Look at your city attorney. Okay, I'm trying to be really careful to stay with the material in the record. This is just another example. The criteria, the approval criteria is dramatically different between what it was applied when the council applied the site review subdistrict to the Whitaker properties. Compatibility was defined as, address glare and visual buffering. Well, the new code, 2001 code, which remains in effect today, the overlay zone uses broad discretionary terms like it's reasonably compatible. And it has you look at building locations, bulk and height, issues that weren't even on the palette of discussion before, the old one. You saw today, and it bothers me that staff keep referring to policy 2 on page 50 of the Whitaker plan, or 32 actually, in part. That policy was amended by the city council, when the planning commission forwarded the recommendation on the Whitaker plan, policy 2 was in place, but the council added this to policy 2, and it's still in the Whitaker plan. And it's the Eugene Planning Commission shall consider initiating actions to remove site review where appropriate when citywide design standards have been adopted. That was 25 years ago. That's a long time for this item to have not made it to the Planning Commission's work program, if indeed you believe site review overlay still exists. The hearings official erred in concluding that because the Whitaker plan anticipated the city would reevaluate the need for site review, that an individual applicant bearing the burden, and it is a burden to be here, that the need for site review cannot be privately initiated by an individual property owner to remove it. There's nothing in the code or the Whitaker plan that says that. It directed the Planning Commission to initiate removal of site review. It hasn't occurred. If you believe the staff that site review subdistrict's the same as the overlay. So please allow this to be considered and respect this process. I'll just jump through this. There were extensive citywide design standards in 2001, multifamily standards, which you're well aware of, commercial standards. There were also standards addressing bike parking, landscaping, motor vehicle parking. You're probably the most familiar with the current code. And in 2001, the bulk of the code that you're familiar with was put into effect. We didn't have landscape standards around parking lots. You know, this was a major comprehensive update. So that is why we believe the need and necessity for site review sub-district or overlay, if you believe it applies, it should be reevaluated and removed in this case. The citing criteria, the hearings official made an egregious error. The specific criterion is referring to the SW Whitaker Special Area citing requirements. We're not talking about changing the base zone. That citing requirement isn't even relevant. If it is relevant, let's read it. The site must be planned for a special mix of uses in the Whitaker neighborhood plan. It doesn't mean the applicant has to prove they have a special mix of uses planned. You can have a single-family homeowner or a small business tenant doing commercial or an industrial owner, and you can still have the SW zone. What this says is the Whitaker neighborhood plan designates it for mixed use. That is very evident in the record. So what is interesting about this citing requirement is properties only need to be designated for mixed use in the Whitaker neighborhood plan to get the SW. The code does not require, in order to get or retain or have the SW zone, there's no citing requirement. The property must be subject to the site review overlay zone. That's an example of how you can fix a code and address it if you want to apply it. But it doesn't say that. So it's hard for us to prove we don't need it when it's obvious it's not required. It's kind of hard to prove the opposite. So I think I'm going to skip through these very quickly. I have provided you photographs of the subject properties. You can look at those at your leisure. I will just leave you with one thought. The site review requires new development or an expansion of a building more than 20% to be reasonably compatible. That's extremely burdensome in a neighborhood with such a mixture. There's no dominant architectural style, there's varied building setbacks, and there's a mix of building heights. And we certainly don't want to see a case where somebody's trying to do a compatible design with the jail or some of the other uses that surround these properties. So with that, I will conclude.
Pass the conch.
Yes.
Okay. Thank you, Bill Close, for the appellant, 375 West 4th Street, Suite 204. So we really have two issues, as the staff outlined to you. And Teresa spent most of her time talking about assuming the site review is on this property, are we really entitled? Have we made a case to remove it? By the way, welcome to the new commissioners. As you can tell already from Teresa's remarks, zoning controversies in Eugene don't get any more exciting than this one. As we told, I'm going to focus on, is site review on this property in the first place, which is the threshold question. And we were late in coming to this issue. We didn't think about it until we got this staff report to the hearings official, which was pretty negative. And Teresa started digging into that staff report, and as we explained to the hearings official, Teresa was in charge of drafting the code in 2001. She was there, on the ground. And after doing some digging, she came to me, she said, Bill, she said, I don't think site review ever got put on this property. I said, really? That's interesting. So then we dug into that issue, and we posed it to the hearings official at the hearing and said, we are entitled to a determination as to whether or not site review was ever put on this property. And she agreed we were entitled to that determination. Staff shifted gears and said, oh, yes, it was. That became the bulk of the hearings official's decision, resolving that question. So I want to focus on that question. By way of a global overview, I've given you a 2-page letter, which is unusual for me, which is backed up by a table. And the two-page letter, what I've done is hold out one long Germanic sentence from the staff report, page 3 of the staff report, and I've broken it into its constituent clauses, and I've put that in bold font there, page 1 and page 2 of my letter. So everything you see in bold there is one sentence pulled staff's conclusion from the staff report. It's a good summary of how the staff views the hearings official's decision, and it's an accurate summary, I think. So if I could, I'd just like to focus on each clause, and that will really be the glossy overview of our pitch on this issue, whether or not site review was ever put on this property in the first place. Now, you have to go down to the last bold clause at the end of the second page, because everything else is modifies that, you know. So go down to the bold print, the bottom of the second page. It says, based on the above, the hearings official denied the applicant's request for a determination that the site review overlay zone does not currently apply to the subject properties. So now let's go back up and look what the clauses are that lead to that conclusion. Number 1 on page 1, the city's actions in 1994 to impose the site review when it implemented the Whitaker Plan. That's correct. In 1994, the city, after adopting the Whitaker Plan, put the site review sub-district on this property and everything else in the mixed-use zone. But as the hearings official explained in the recent decision that was summarized by Teresa, the site review sub-district was a very, very different zone from the current site review overlay zone. They're different animals. But it's true, the site review sub-district was put on the property in 1994 after the refinement plan was adopted. The second point, the city's actions in 2001 when it adopted the current land use code. Well, in 2001, the city, as Teresa explained, repealed the former site review sub-district zone and adopted the new site review overlay zone. All of the sub-districts were repealed. It's right in the title of the 2001 Luku ordinance. In 2001, the city did not apply the new site review overlay zone to any specific properties. When we look at the table that I've attached to my letter, we will see that in more detail. In 2001, the city did not do a wholesale reclassification of the site review sub-district with the new site review overlay zone, in contrast to the base zones. For the base zones, right in the ordinance, and it's 2001, and it's still in the current ordinance, there is a table that says if you have this zone from the old code, you get this base zone in the new code. And that isn't, the sub-districts weren't handled in the same fashion. There is instead just a listing of the new overlay zones that were being created for the first time in the 2001 Luku. No reference to the old sub-districts other than the title of the ordinance, which says those are repealed. So the Luku code handled the base zones very differently from the sub-districts and the overlay zones. Point 3, the city's legislative intent as it is reflected in ordinance number 2224 and in the city's actions since 2001. Okay, this is the legislative intent question. The Luku ordinance in 2001 did not state a legislative intent to change all the properties with the site review sub-district to the site review overlay zone. There's no statement of legislative intent to do that. In contrast, it did do that for the base zones, as we've discussed. Regardless, and to pick up on a point Teresa made, and to focus on a very basic rule of interpreting codes and statutes. If the language of the code on its face doesn't support what you think is the legislative intent, you amend the code. You don't amend the code by interpreting the code the way you want it to read. And we have a long, tedious, but otherwise exciting appeal statement. And in that appeal statement to you, we've outlined that basic law, how you read codes and how you read statutes. Point 4, the city's current overlay zone map. Okay, first of all, we don't have an officially adopted overlay zone map. If you ask the staff to go get an overlay zone map, they'll print off what's online. If you want a hard copy, they'll get it from LCOG. All that just is a dump out of the RLID database. The city council has not officially adopted a consolidated overlay zone map, period. Hasn't happened. In contrast, the city council has adopted official zoning maps for specific overlay zones. And we'll talk about that in conjunction with my table. Indeed, for every overlay zone that was created in 2001, individually for that overlay zone, the city council adopted a specific map. That's the official map for that overlay zone. But the city council did not do that for site review, and they did not do that for plan development. More in my table that follows. All indicate that the subject property is currently encumbered by the site review overlay zone. Nonsense, I said. That's a little glib. But that's the right, that's an editorial. The city council has not adopted a map placing the site review overlay zone on this property, period. No official map doing that. The 2001 LUCU ordinance did not state that all site review subdistrict properties now are site review overlay properties. It's not there. And so with that, I'm going to refer you to my nifty table that is attached to my letter. I kind of like tables. People aren't that smart, need tables. So what I've done here, I've got 3 columns in this table. And in the left column is specific overlay zones. In the second column is the reference to where in ordinance that specific overlay zone was applied to specific properties by the city council. That's what it takes. You create a zone, an overlay zone, and you apply it to properties. And the city council has to do that. And in the third column, I have the operative language from the ordinance that actually applied that specific overlay zone to somebody's dirt, okay? So we're going to walk down through those very quickly. The first bunch of these all are the new overlay zones that were created in LUCU 2001. First one, Commercial Airport Safety Overlay Zone. There it is, 2001. There's the section 9.4110 that applied it to specific properties. And then there in the third column is the language from the 2001 ordinance that actually applied it to a specific map. And when you turn to Exhibit A, there is the map from the 2001 LUCU ordinance that actually shows the footprint of where that CAS zone overlay zone was applied. So, zone created, zone applied, as shown in the map. I'll shorten this up. You go right through this table, and it's the very same for every overlay zone, with the exception of site review and plan development. Number 2 there is kind of fun because it doesn't exist. The Hillside Development Overlay Zone, created in 2001, never implemented. It's kind of a panda's thumb. The third one is interesting too, because it's the Nodal Development Overlay Zone. That overlay zone was created in 2001, but it wasn't applied to anything in 2001. It was just created. And look in the second column. It was actually applied for the first time in 2003. And where was it applied? It was applied in the Crescent Avenue area, the Crescent Avenue node. Just look at that Exhibit B, if you will. There you have a map that was included with the ordinance that the City Council passed in 2003, actually applying the Nodal Development Overlay Zone to a specific chunk of dirt out there in Coburg Crescent. And so that map you're looking right there is the official, I should shorten this up a little bit. Okay, so there's a pattern here. You kind of get the pattern. That is a map. This map is the official overlay zone map for nodal development. Plan development, there is no map. It wasn't applied anywhere. Site review, no map. It wasn't applied anywhere. And the whole next page runs right down all the way down to the bottom of page 2 of my table. When you get to the bottom of page 2, we move into the current age after 2001. Overlay zones that were created after Luku. Now, I've only picked 3 of them here. Overlay zones in Eugene, in the Eugene zoning code, kind of sprout like mushrooms in the fall. They just keep happening. Here's just 3 of them. But it's the same process. It's created in an ordinance, Water Resources Overlay Zone, 2005. Some of us were here for that. The specific section of that ordinance, section 29, refers to a specific map. And I've included that map or a piece of that map in Exhibit E. So that's how it works. We don't have a global official overlay zone map. We have a series of specialized overlay zone maps. You can't say a specific overlay zone was applied to this property without pointing to an ordinance and a map sticking that overlay zone on this property. And for site review, there is none. That's the gist of our argument and why site review does not stick to us. We're being told to wrap it up. In the most polite terms, anything I've forgotten, Teresa?
Just that we acknowledge that since 2001, there have been privately initiated individual zone change requests, and there have been cases where the hearings official or the Planning Commission on Appeal has applied the new site review zoning overlay or the plan development overlay zone. So that record is clear. We're talking about the pre-2001 subdistrict properties that are.
That's right. All of these overlay zones have, in the context of site-specific decisions, been applied to one property or another. We're talking about, what happened at the time these overlay zones were created in 2001, and whether it was ever stuck on this property. And the answer is no. Now, my final comment is kind of a big picture, global comment. The staff report took the tack that I thought it might, which is to say to you folks, you don't really have authority to get into this. This is beyond your pay grade. You can't make this decision without really having the roof come down on top of the zoning map in Eugene and without having the floor drop out like buckling plate tectonics. That's the Pee-wee, the sky is falling theory. And I mean, how do you feel about that? This is really beyond your pay grade. You don't have authority to do this. Some of you might say, it's nice to be off the hook. And others of you might say, I take umbrage at that. I mean, all of you are overeducated and underpaid for the job you're doing right here. It's not that complex. Don't let the staff steer you to the parade of horribles if you find, as a matter of law, that this property is not subject to the site review overlay. That's the only question you have to answer. And if it turns out that the site review overlay zone does not apply to a lot of properties in the city, that the city thinks it does, there's an easy fix. You go apply it with a new legislative enactment, just like the Court of Appeals suggested in the case law that we summarized for you in our appeal. Thank you very much.
Thank you. Teresa, Michelle, can you just state your address for the listeners?
Yes, I live at 3520 High Street in Eugene, Oregon.
Perfect. Thank you very much.
Thank you.
And it looks like we have 2 other, so we don't have any neutral. So we're going to move to opposed. And I have first Piper Farney. And please correct me if I mispronounced your name.
No, ma'am, that's entirely correct.
Right.
And thank the commission for hearing me. My name's Piper Farney, as you said. I'm a resident of the WIT. I'm a libertarian, so I hate to say this, but I think the government made a good decision in this case. The gentleman had a number of technical arguments against the appeal, against the decision. but I want to come back to the base argument and the responsibility of the commission, which is the public good. All of the changes in 2001, LUCU, I'm sorry, I'm not familiar with these terms as much. All the changes seem to be for the public good, increasing things like bike parking, setbacks, landscaping. None of those things seem to actually burden individual homeowners. Case in point is if a single-family home burned down, the single family could rebuild on the exact same lot without imposing a site review, as I understand it, because it's the exact same footprint. So I come back to, I don't understand what the public good would be in overturning the appeal. And that's pretty much my entire point, is what is the public good? Thank you for hearing me.
Thank you. And next, I have Mary Kate Land.
Hi, my name is Mary Kate Land. I live at 37 Ash Street, which is in the Whitaker as well. I was here for the last meeting where the hearing official heard all the evidence that was laid down and made a decision that is now being appealed. And at that time, there were a lot more people here to represent just the folks who live in Whitaker. And I was a little worried that they wouldn't all come back. But I did want to say that the general feeling was that the hearing official was making the correct decision in having the site review still apply to the property. And again, the question, how does this benefit the people of Eugene to not have a site review in place on this property? Thank you very much.
Thank you. So that is, unless somebody snuck in, it looks like they didn't. Any staff questions or questions from the Planning Commission? Why don't we start with staff really quickly, if you have any comments or questions, or if you want me to start with Planning Commission.
No, I don't have anything to add.
Okay, great. Yep, Commissioner Borowski.
I was just wondering when it was going to be appropriate to ask questions of the people who presented testimony.
I think now is great if you want to ask a question.
You guys want to come back up? I have a couple of things that I just needed to get a little bit clarified on.
Back by popular demand.
Yay. Thank you for coming back. Thank you for your testimony. Mr. Close, in the letter that you put on June 11th, there was a sentence there towards the end, and it kind of threw me for a little bit of a loop. It says, the interpretation at issue here needs to be correct, needs to be the correct interpretation. If the Planning Commission guesses wrong, then LUBA will start from scratch and try to get it right.
That's right.
So are you wanting us to guess on this?
No, that's not what I'm saying. The point I'm trying to make there is that the question that's before you is really a question of law. Right. What is the zoning that sticks to this property right now? Yeah. And the plan and the code are city law. And so we're just asking for what is, the question is, what is the law? Right. And staff and the hearings officials say that it's X, and we say that it's Y. Right. You make the same determination from scratch with no deference to the city attorney or the staff, and whatever your answer is can be appealed to LUBA, and LUBA does the same exercise, applying the same rules with no deference to what you've decided or what the staff or the hearings official have decided. Okay. It's just everybody guesses at what the law is. Okay. But you're supposed to apply certain rules in making that guess.
Right. And then, Teresa, in going through the minutes of the city council when they enacted the LUCU in February of 2001. It made reference to staff that was at the table, and your name is listed prominently there. You were the lead staff person on the LUCU process.
Yes, I was the project manager within the planning division, and I was working closely with the city attorney's office and other staff.
So when you came to the conclusion that was stated here earlier that by Mr. Close, that this may have just kind of fallen through the thing, or was it, I'm trying to find legislative intent here, because I can see it both ways. I can see an argument that has been made that says, oops, we missed something, and we didn't put the map in into the other thing. And I also see some legislative intent that says these issues are being addressed in other forms. And so as leads, I don't know if this would be new evidence or not, but I mean, as lead staff, do you think it was one or the other?
I think it's a combination of factors that led to the 2001 code adoption. One of the biggest factors was you were dealing with a comprehensive update of over 200 pages of code. And so the emphasis throughout the entire process was placed on the text of the code and the standards, and there was a profound amount of policy choices to be made. The hillside development standards is a good one. It was identified as a need. It was put on the table, hillside development standards, but there weren't the resources to actually develop the overlay zone. Was there legislative intent? Was there a hope? Yes, there certainly was, or they wouldn't have put it on the table, but it didn't happen. I can't answer the question as to why the comparable table to reclassify the subdistricts was not done, but I can tell you it wasn't done. And it was one of the hardest dilemmas I faced, admitting an error on my part. I mean, I do feel responsible in part for where we are today, because I could have done the table and I didn't. It wasn't that a table was prepared and removed. I wasn't done. It's not there. But beyond that, you go back to the one slide we showed, which is it's good, it's healthy to look at legislative intent, but you can't make a land use decision based on somebody's aspirations or somebody's belief that, well, this was what they thought happened. No, you need to actually look at what the legislation is that was adopted. And the moment the mixed-use Whitaker zone, the MUW, was repealed, it went away, and the new SW came into effect. The same happened with the overlay zone. And the policies in the Whitaker plan don't talk about at all applying the site review overlay zone to a zone that didn't even exist in 1994. So we have a challenging situation. And I will say, step up and you can do this. It will be hard evaluating it. And we do want to grant you the time that you need to make that decision. And I'm heartened to hear you're not planning on taking action tonight so you can mull things over. And it is hard. If you start to look at it and it feels hard, it is, but work through it.
So can I kind of pause for a minute in terms of response to the question? Let's make sure we get some other questions, and then you'll have time for rebuttal so that you can kind of wrap it up. Any other questions from the Planning Commission? Okay, so that's why I was thinking there might not be any other questions. So now it's rebuttal time unless staff, if you have any, you didn't.
If I could follow up.
Yeah, so now you've
with
got
on Teresa's
rebuttal.
point and just offer a very simple analogy. If you write a sentence that has an I in it and a T in it, and you forget to cross the T and dot the I, and you look at it later and you say, oh, well, of course, I intended to cross the T and dot the I. You don't assume that they are dotted and crossed. You go back and you do it. And it's the same situation here. You don't say we obviously intended that the site review overlay district would be applied everywhere that there used to be a site review subdistrict, and so we assume that it's done. You instead go back and you actually do it.
So you can keep going. We have 10 minutes.
Okay, I'd like to make a few brief rebuttal comments. There was testimony tonight regarding the public good, and I wanted to provide the applicant's perspective on why site review is an unnecessary burden in this case. Site review in its current form creates a high degree of uncertainty. It's extremely hard for a property owner to even have a vision for modifying their building, expanding, doing something new. If they have broad approval criteria such as reasonably compatible, and you have a jail with a chain link fence, or you have the type of property surrounding the 10 lots that are in discussion. So creating a high degree of uncertainty is one downside. The site review causes unnecessary delays. If you look at the history of site review, it is rare that a condition or design change was made during the process that the design team would not have come up with on their own. And the more the land use code has standards addressing, varied building heights, if you're a commercial zone next to R1, there's so many standards addressing compatibility, the delay factor, and we're talking 5 to 6 months. We're not talking a few weeks. The third is the cost. There's evidence in the record from Carol Shermer, who works extensively on site review applications. And the cost can be $50,000, $60,000, $70,000, regardless of the size of the project. There was testimony tonight that a new home could be built in Whitaker with site review if it burned down. Okay, that's interpreting the code a certain way. The code says site review is required if you have the overlay zone for any new development. It doesn't say unless you previously had a building and you're going to rebuild in the exact footprint. That is an example where it causes anxiety, stress, uncertainty for somebody trying to, understand their rights. What if the home was damaged from an earthquake? You can rebuild if it's a non-conforming use, but a house in the Whitaker mixed-use zone is not considered a non-conforming structure. It's a permitted outright use. So you don't go to the non-conforming section, which allows you to rebuild. And the majority of properties in Whitaker with this site review overlay, and I'll just speak to our clients' 10 properties, have never gone through site review. So there's not an approved site review plan that they can just rebuild according to the approved site review plan. There isn't one. None of our clients' properties have an approved site review plan. So he has to start completely from scratch if he wants to do anything that triggers site review. I do appreciate the testimony that the 2001 code appeared to address the public good, and I think it made a significant, profound change in our land use regulatory arena. And since then, the Planning Commission and Council have added more code amendments that have further strengthened addressing compatibility. So I just urge you, now's the time to reconsider the need for site review and to remove it from these properties. There's no compelling public good to retain it.
I'd like to follow up, emphasize Teresa's comment about the time and the cost of putting anything through site review. And we put evidence in the record. She referenced a letter from Carol Shermer, who does a lot of those. And that letter is very candid in saying, on average, 9 months and $75,000 to get through site review process. So friends don't let friends go through site review if it's not absolutely required. So that supports primarily the rationale for removing site review if we assume that it is on the property at the moment.
Any? that's it.
That
I-
concludes our rebuttal
Thank
you.
comments.
Okay.
No, I think, unless you
No.
have questions, I think that, yeah, I think that concludes our comments.
Great, thank you.
And last comment,
Yeah,
if you
of course.
need more.
I knew I was waiting for it.
No, okay.
I could tell. I could tell. I hesitated.
Last word imperative. I heard you say you had a July 9th deadline for making a decision. Take all the time you want. 16th, fine. Take all the time you want.
Are we getting an offer in writing to extend the 120-day deadline?
I'll give you whatever you want. In writing.
Okay.
Take what you need.
Reasonable amount.
Take what you need.
Yeah.
9 months and $70,000 would work for me.
Thank you.
Thank you.
Thank you. So I'm going to close the public hearing. And we have a couple of procedural items that I want Lauren to address.
Can we also close the record?
Oh, sorry, I do that every time. And I don't have to, I won't do that again, but we're going to close the hearing and close the record. Thank you.
Does that take a motion?
Would you like to make a motion?
I would move to close the record in the appeal hearing. The appeal of the hearing's official denial of the zone change for Simon Investment, City File Z19-1.
Perfect. Any discussion? All those in favor?
Aye.
It's unanimous. Thank you. Yeah, thank you. So a couple of things. I want to, Lauren, can you start about the new evidence piece? And then I want to poll people to see where they are. If you're actually prepared to start deliberations tonight, I want to make sure that I check in. Okay.
So quickly to new evidence and/or arguments outside of the appeal issues presented by the appellant. You were presented tonight with an email dated June 24th. Oh, maybe you weren't presented with it. From Kathy Feely. This is testimony that came in after the staff report was provided to you. And turning to the third full paragraph of that email, I think the first sentence is not new evidence, but the following sentences are not already in the record, talking about, we already have serious traffic issues on First Street with pass-through traffic from Ferry Street Bridge / downtown. So it's a discussion of traffic issues, how it's hard to cross First Street, how there's been a death, they don't feel safe. She has a video about how traffic is backed up. I checked in with Rodney, and he's confident that that information was not in the record before the hearing's official. So our recommendation is that the Planning Commission reject all but the first sentence of the third paragraph of the email as new evidence and not consider it in making your decision.
Someone willing to make a motion?
I move to strike all but the first sentence of the third paragraph of the letter received this evening.
Second. Any discussion?
And just that paragraph, right?
Yep.
The following paragraphs are okay?
The
way you presented it, I wasn't sure.
that's my understanding.
Okay, so just the last part of third paragraph.
So it's been moved, it's been seconded, and just to clarify, this is the Kathy Feely email to Rodney Bonner as of June 24th, 2019. Discussion? No? All those in favor? It's unanimous? So did you have any other concerns about the presentation this evening?
I would just remind the Planning Commission that, again, you're limited to the appeal issues identified by the applicant to the extent that there was testimony, either written or oral tonight, that sort of strayed beyond those appeal issues. You're not required to affirmatively reject it like you do new evidence, but you should not consider it. The issues that are before you are the two appeal issues identified by the applicant. I will also point out that and Ronnie, please correct me if I'm mistaken about any of this, the handout that was provided to you by the applicant tonight includes a table and maps that staff hasn't had much time to go back and verify whether or not they are included in the record. It's my understanding that the table itself and the specific maps are not included in the record. The information in the table is, I think, and it appears that all of the information and the maps are from city ordinances or adopted by the city, and so those are things that you could take official notice of. They don't constitute new evidence. So I just wanted to point that out to you in case there were questions, but I don't have concerns about you considering that information provided by the applicant.
Okay. So, as you heard, we aren't, the applicant is basically extending the July 16th deadline if needed. I want to check in. It is 6:45. Are you able to and feel prepared to start deliberations tonight? That's what we were going to plan. I just want to make sure.
I need to review the record. The record is quite large, and I went through a good portion of it, but I would like to review more of the record before we start deliberations.
So do other people, have they done their work? And, because there will be more deliberations, obviously. We have the July 9th date that was set.
I think we have 2 dates.
Well, we only have one date at this point. We have July 9th, and then there'll be a poll that goes out to get additional dates.
And only half of July 9th.
Pardon me?
Well, 3/4 of July 9th.
Yeah, exactly. There's some
hour,
time.
yeah.
So, yeah, that's why starting deliberations tonight would be great, but I want to make sure people have read the materials. Commissioner Fraggle.
I, just so everybody's aware, I won't be here on July 9th to finish deliberations, but it's perfectly acceptable to me if we begin a conversation tonight.
Okay. So, so if everybody feels comfortable, so you've had a chance to review the materials, you just wanted more time, because there will be,
Well, there's this material that came in, and, the record is, and, there's some points made that drill back into previous information.
Commissioner Borowski.
For me, I think I'm comfortable with starting the discussion and getting it going. A lot of times, that helps me go back, when the discussion starts, that helps me go back and look into the record and actually dig down and say, oh, yeah, okay, where can I find that in the record so I can quantify it? So for me, it would be helpful to at least start the conversation. I'm not in no means ready to make a final determination this evening, but I think it's wholly appropriate to start a discussion on the issue. At least that's my opinion.
Okay, let me get a straw poll vote, those that feel like they can start deliberations tonight. We don't have that much time, we have 40 minutes. All those in favor? Okay, all those opposed? Okay, so we'll proceed. Why don't we start with just questions you have for staff? Or if staff has any opening comments, anything you want to start with? Okay.
Questions from staff?
I was asking them if they had anything to say before. No?
Nothing
Pass?
that's
Okay,
other than what's in the staff report.
perfect. I have Commissioner Fraggle.
I'd actually like to hear staff talk a little bit about the far-reaching unintended legislative consequences that could result from this decision. I actually have significant concerns about overturning the hearing officials' decision based on some of the comments that were made in our packet. And, I mean, I think I have an idea of like how far extending it could be, but I was hoping staff would elaborate on that a little bit. Because I personally think it's an important thing to consider.
Well, I would start by saying that if you're following the appellant's argument, essentially any, what was originally called a overlay district? Sub-district, sorry, overlay sub-district. Before the LUCU in 2001, generally they were changed to follow a lettering and numbering and naming system that's consistent with the new codes after 2001. If you go with the applicant's argument, you essentially all those overlay sub-districts wouldn't exist anymore unless they were explicitly added through the ordinances and in the table. Beyond that, part of the applicant's argument is that we don't have a zoning code map or an overlay zone map. So, I mean, we don't have any zoning would be the extreme logical extension of part of the argument.
Yeah, I think there are a number of different things we could try to extrapolate from the reasoning or their arguments, but I think one of the concerns is that, and understandably, this is a quasi-judicial decision about 10 specific properties, but to the extent that the interpretation about the overlays, their applicability could be relied upon in future applications, we could, see a series of applications individually over time that would effectively erode, the existence of these without necessarily having what we believe ought to be a legislative decision by the Planning Commission and City Council to really resolve if there is an underlying question or concern about the Whitaker Plan policy, or more fundamentally, the way in which the land use code was adopted whole cloth in 2001. It fundamentally has this sort of gaping hole with regard to overlay zones. Our discussion of it here is really expressing some concern about that needing to be a legislative decision that looks at it in a much more comprehensive manner. I don't know, do you have anything to?
Sure. I would say that in the hearings official's decision, she talks a little bit about whether what the applicant is really doing is presenting a facial challenge to the ordinance adopting LUCU, which is to say that there's something wrong with that ordinance, the city council got it wrong. And if that is the case, then it's too late. That should have been done back in 2001. If the hearings official then went on to say, in the context of a quasi-judicial application, she can consider, and therefore you can consider, whether site review was applied to these specific properties. You do have that ability to make that decision or to decide, whether you agree with the hearings official's decision on that point. But I think what staff would say is, and what the hearings official did say, was LUCU, the land use code update in 2001, doesn't really affect whether site review applies to this property. The requirements of site review were formally imposed on this property in 1994 as part of the Whitaker Plan adoption process. And nothing since then has formally removed those site review requirements from that property. The Whitaker Plan hasn't been amended. LUCU didn't specifically reach to this property and pull off the site review requirements, so they remain. They were imposed by an ordinance that was not LUCU, and they were not repealed by LUCU. They were not formally pulled off of the property by LUCU. So LUCU doesn't really actually have much to do with this decision. Site review continues to remain on the property. That's what the hearings official determined, and that is, I think, staff, you jump in if you think if you would say something a little differently. But
I think that's right, and, you know, there's a point at which I think we need to kind of circle back and look at the hearings official's decision and the wording she used, but there was a portion of her decision that explained, you know, that at least in the context of the second zone change approval criterion about being consistent with the applicable adopted refinement plan, that they never really articulated the basis in terms of the intent of the policy. Says, in fact, the applicant has not provided any evidence to establish how removal of site review from the subject property is consistent with the Whitaker refinement plan. As recited above, and this is a quote from the plan, I believe, the Whitaker plan contains policies to apply site review to property with the most significant potential for compatibility issues being raised during new development or redevelopment. And so they never squared off with that issue or that intent as expressed in the plan. Correct.
So procedurally, I just want to clarify, since I'm going to proceed, I was thinking there might be some general comments, but because we only have two appeal items, we'll just start with appeal item 1, a similar procedure that we did the last time through, and those that weren't here. We basically are going to have discussion, and then when we feel like we're ready, we'll take a straw poll vote on each of the appeal items. Granted, you know, it doesn't have to happen tonight. I'm just talking about procedurally. So if that works for everyone, unless somebody's got a generic comment or question that they want to make before we do that. It looks like, hey, hang on one second. So
I mean, generic question about.
just the procedures, the process, and then we'll dive into appeal item 1. Okay, Commissioner Baker.
Yeah, I just had a question. Again, my understanding is that there's a hierarchy. We have state land use requirements, then we have a metro plan, and then we have neighborhood refinement plans. So if these other ones don't speak to the issue in particular, then it defers to the refinement plan, and I'm just asking for clarification on that.
Your understanding of the hierarchy, or?
Yeah.
Well, yeah, generally speaking, our comprehensive plan locally needs to comply with state law. And state law provides the directive for each local jurisdiction to have that comprehensive plan. Our comp plan includes the Metro Plan, Envision Eugene, and a whole host of neighborhood refinement plans that have been adopted. And I sort of see those as an umbrella, or if you want to think of it the other way, as an underlayment for the city's code. And all of these things need to nestle together and be consistent. Does that help?
Okay. So we'll continue. Commissioner Fraga started kind of the discussion for appeal item 1. So if you can bring up appeal item 1, and then let's just continue with questions to staff. And did you have one? Did I?
No, I was just going
Peripheral
to talk
vision.
to appeal item 1.
Okay, great. Would you like to?
Sure.
Okay, Commissioner Borowski.
So for me, the applicant made a compelling argument. And this is something that I wrestle with on appeal issues all the time. And usually it's going the other way. Usually it's neighborhoods have very compelling issues that I'm bound by procedural code that says you have to do it this way. And I sit across the table from neighbors and say, you know what? I hear what you're saying. I understand what you're saying. But procedurally and by code, I have to abide by this. And I'm kind of in the opposite seat here, because now I'm in a position where I'm having to say that to the city. And I'm having to say to the city, I understand that this is going to be a tough nut to swallow, but somebody got it wrong. And there is an avenue to fix it. It's not a cheap and it's not an easy avenue to fix, but I'm gonna have to go back and dig in. Again, I'm not an attorney, and this is where it makes it hard, because when we're looking at expert testimony on other appeal issues, a geotech, and I've got one engineer that says this and one engineer that says that, and how do I weigh that in? Well, in this case, I've got one attorney here, one attorney that's the hearings official, one attorney over there, and a very experienced planner, ex-planner. And how do I balance these? I understand Commissioner Fragala's concerns about the overarching implications of this, but that's not my job. My job is to look at these 10 properties and decide whether or not site review applies to these properties via the criteria that's given to me. And that may have unintended consequences, just like other appeal issues that we've had. Not so much zoning appeal issues, but PUD appeal issues. On one of those, when we thought grading was a different definition, that had unintended consequences. So as I go back and dig into this, I heard compelling arguments from the applicants. And I'm kind of a, Lauren can attest to this, I'm kind of a wonk on these types of things. Should the record be closed at this time? Do they need to gavel that in? I asked her that at a public hearing the other night. And procedure matters, especially with legislative issues. And if it's wrong, there are ways to fix it. So when I'm looking back at this, I can't look at, if I do this, it's opening a can of worms. I have to look at it and say, are these 10 properties subject to site review via the code that I have to look at? So that's where I'm at, and that's what I'll be digging into. And unfortunately, to me, that means reading a bunch of LUBA decisions that were cited in the record.
So I'm going to put myself in the queue. So staff, can you please, this is a interesting and tough appeal item in front of us. So I would really love some assistance in terms of what our decision is based on today in a quasi-judicial process, and the responsibility of Planning Commission. I've got we have to use materials and information that's already presented, which we've evaluated at least most all the materials. They're going to look at some of the additional materials we received tonight. And then 2, whether or not we think the hearings official made a mistake based on approval criteria for the zone change and evidence she had at the time. So I guess that's my question, is kind of explain to us where that threshold is of digging into the past and looking at intent of an ordinance that was adopted in 2001 or 1994. So explain to us, because the evidence in front of us, which then brings me to this, the applicant is talking about, the appellant is talking about, there isn't an adopted overlay zone plan. So kind of, if you can discuss those items, I'd appreciate it.
Sure. So to the extent that you believe there is a need for interpretation of the 2001 Luku ordinance, as the applicant pointed out, you would first look to the text of the ordinance. What does it say? If that is unclear, then you can look at the context. What does the rest of the ordinance say? Only then do you look at legislative history. But I would caution that legislative history, sort of the intent behind the ordinance, what staff intended is not the test. The test is what the decision maker intended. So that to the extent that you can kind of glean what the decision maker intended by minutes from that time, perhaps comments made by staff to the decision maker, you can kind of use all of that as context for what the ordinance means, but a statement from a staff person about, what I intended when I drafted an ordinance doesn't count for anything. So that's sort of the hierarchy: text, context, then legislative history. I would say, however, that once again, it was the hearings official's position, and I believe it is staff's position now, that you don't need to interpret the 2001 Luku ordinance to find that site review still applies to this property. The timeline, as I understand it, is that the Whitaker Refinement Plan was adopted in 1994. The plan requires that site review be applied to all properties zoned MUW Whitaker mixed use, which was the base zoning at the time. So when the Whitaker plan was adopted, all of these 10 subject properties were zoned MU Whitaker mixed use through a city-initiated zone change. The city council said, yep, I'm pointing to these properties, we are going to zone them MU Whitaker mixed use, and at the same time applied site review requirements to those properties through what was called at the time a site review subdistrict. Then, in 2001, during the big Luku update, all of the properties zoned MU Whitaker mixed use were reclassified. So that was that table that Teresa was talking about. Their names were changed to SW Whitaker Special Area Zone, which is still the base zone of all of these properties. Luku did not specifically, did not include a similar table for subdistricts to overlay zones, but it also did not reach into that property and formally remove the site review requirements from those 10 properties. When the applicant talks about the zone being repealed and a new zone imposed, the subdistrict being repealed and a new subdistrict imposed or not, that is not my understanding of what happened in Luku. It was a reclassification. It was a change over from what we called the zone before to what we call the zone now. And in order to repeal, to pull off, formally remove those site review requirements from those 10 properties, you would need a formal, specific council action zone change. And there's no evidence in the record that that ever occurred. So, given all of that, the hearings official said, I believe that site review still does apply to this property. Then the second question becomes, should it be removed, which is the other thing that the applicant is asking for. So that was a really long answer to your question, but in terms of, how would one interpret the 2001 Luku ordinance? Text, context, legislative history. Hearings official and staff's position is you don't really need to.
I guess I would just add there are obviously competing theories about the legislative history, and I think Lauren captured it well. And I think one of the threshold questions for the commission is whether you even need to reach that with regard to the land use code update. But more importantly, I think you mentioned it, in terms of framing the commission's role, I encourage you to look, and particularly if you're digging back through the record and sort of considering the appellant's arguments, is to frame your thought process around whether or not the hearings official erred. And so really using her decision as a guide. And if you feel that there are compelling arguments that were made in the appeal that cause you to believe that she erred, it would help staff a great deal and I think facilitate your decision-making process to be ready to articulate what it is, where it is that she may have gone wrong, and why you believe that to be the case based on the arguments that were presented. So the more we can get specific in terms of those arguments related to her analysis and why you think she's wrong or not, that will really facilitate deliberations.
Perfect, thank you. Any other questions or comments? Yes, Commissioner Ramey.
Thank you. So, like Commissioner Borowski, this is a really interesting and knotty problem, as I guess that's why we're here. If it was easy, we wouldn't be here at 7 to 10 on a Tuesday, whatever day is. So for me, I think the issue is most simply articulated by a difference in sort of geographic tying of an action and changing the text of a description. So in the case of the site review, the word site review, the phrase site review is present in both cases. It's a site review overlay, and it became, no, I'm sorry, it's a site review subdistrict, and it became a site review overlay. So that's a simple, maybe a stretch here, but that you're changing the text. The ordinance at no point did not reach back in geographically and say, these specific areas, these tax lots, we're removing something from them, period. Didn't say that. It said we're changing the text that describes how we're regulating them, but it did not ever remove the sort of explicit geographic location for those. What I need help with from staff is the argument that, well, since we were changing the overall basic zones, and that's clear in the ordinance, change from this to that, but there's no corresponding changing the sub-districts. It's almost as if that ordinance was silent on that issue. Or at least that's the argument the appellant's making, is that base zones were changed, sub-districts were not. Therefore, sub-districts go away. And I think that's our challenge. And where I'm coming at it myself is, well, these were assigned to the specific properties at the time in 1994, and nothing that LUCU or the council did in 2001 changed that. They changed the description of the action, but they didn't change the action. And so that's kind of where I'm coming at, is it's a difference in geographically tying something on the land versus changing the way we're titling what that is, and in some cases, the content of that. But those are two different things. And to me, I think I hang my hat on, while they didn't expressly remove the action. And so I feel like I can honor what happened in 94 because there was there's no intent. I mean, somebody would have brought it up by now. There's no intent in council one way or the other on that. So they didn't expressly say they were taking it out. They didn't expressly say they were leaving it in. So it's hard to find any intent there to help us out. So with that, I'm sort of falling back on what happened in 94, and did that change in 2001? And for these 10 properties, I think right now, no. So I'm kind of supporting the hearing office officials' opinion at this moment, but eager to hear other opinions.
So did you have it in there? It sounded like you might have had a question for
I don't have any
staff.
questions.
Okay.
Well, I'm struggling with that. The argument that's base zone changed, but sub-district, there's no, so we need to find the sort of, where is that in the ordinance that says we're changing both of them, and then we changed this one, but we didn't change that one. I think if I could find that ordinance language, that'd be great. That's it.
Okay, Commissioner Baker.
Yeah, I actually generally agree with Commissioner Ramey on this one. I think the adoption in 1994 that specifically applied the site review overlay to this and other specific properties was the one time where this specific requirement was approved by legislative action by the city council. So that to me says a lot, and also it complies with the refinement plan. So I mean, there's consistency there. There's a reason why it was applied, because it complies with the refinement plan. And if you were going to say you don't agree with this in 2001, that you would have to modify the refinement plan to remove that, requirement from these areas from the refinement plan. which didn't go on either. And also, I'm just curious because obviously, I think we used to call it just site review overlay, and not a zone, although the language in 2001 created it as a zone. But I assume that there are many, many properties within the city limits that have site review overlay, site review attached to them for a myriad different reasons. And I assume that, you know, Luco didn't change any of these other ones either. So I assume that site review and plan unit development were sort of generic district overlays, not that were, when they were attached to a zone, it assumed that they would continue to be attached to the zone, unless they were physically removed by a later legislative action. That's on question 1. So,
Did you say that was a question?
no, that was on appeal item 1, those concerns.
Are there any other questions or comments for appeal issue number 1? Okay. Do you feel like, yes, Commissioner Mason?
Yeah, I guess I'd like to try to make a brief comment on appeal item 1. I think I'm kind of following along with what I hear a couple of people saying. I think at this point, I'm generally in support of the hearings official ruling, and I think this overlay does apply. I found myself thinking when I got into this, I was kind of questioning how far I needed to dig into some of the stuff to sort of check. You know, I read the staff notes, read the hearings official opinion. I went back and looked at the 2001, the ordinance, read through that, and it seems to me, and I guess kind of what I was getting out of it is that all of this was established in 1994, and it appeared that none of that was changed as they went through the 2001 work or the code update. I'm hearing what the applicant's saying that, well, they didn't designate it directly or they didn't change it. I guess I just didn't really read it that way. It appeared to me it was all set in place, and they changed the designation from district to overlay or however it is that it's labeled. So it appeared to me it was all still in place. And I also, as I looked at the zoning map, it all was on there. It seemed to all be pretty clear that in the city records, all the property is designated to have this. And again, I heard from the applicant, well, the city council hasn't adopted the zoning map. So I'm feeling like I need to kind of back and maybe dig a little bit. I need to be sure I listen to everything that's said. But I think where I'm kind of landing right now is it seemed to me that this overlay does continue to apply.
Okay, so I want to get are people comfortable doing a straw poll vote on this? Or should we go to appeal issue number 2, have a discussion around appeal issue number 2? And yes, Commissioner Fragola.
I mean, I'd just like to piggyback on what several other people said. I think, you know, following along with the logic of the hearings official, like I kept looking at the materials to see, well, does that connect, does that connect, does that connect? And like right down to the Whitaker plan, which still has the site review. I feel like there wasn't anything that ever pulled it off. And I liked Commissioner Ramsey's description of that because it clarified it in my mind between the language and the geographical attachments. That was really helpful. So I would like to say I'm leaning towards what I've heard several other commissioners say. I appreciate the need to dig back in, but I would feel comfortable taking a straw poll vote. I won't be here, and I trust the decision-making process of the rest of the commissioners, but I would feel comfortable doing that.
and I'll put myself in. This is, we're obviously here. I can't remember who said this. I think Commissioner Ramey. We're obviously here because this is complicated, right? So it's being appealed. I do think, I always, oftentimes when I review this, I'm like, ooh, I wish, hindsight's, 2020, I wish I think there could have been clarity. Yet, when I look at the evidence in the record in terms of what the hearings official had in front of her to make a decision, actually, I agree, Commissioner Fragola, Commissioner Ramey, it was a good description in terms of this kind of geographically kind of attached from 1994. And yes, you've got sub-district and overlay, and fundamentally, the site review actually, once again, like Lauren had said, is that it wasn't repealed, it wasn't removed. So I can't get beyond that right now in terms of that chronology. So I am, and also the appellants have a very, there's some truth in the argument to some degree. So I think I would probably also say that I would support the hearings official's decision. So I feel comfortable. I think for now, let's take a straw poll vote and we'll move to the second item if we have time. And then obviously, as you read through the materials, if we want to revisit appeal issue 1 in our next meeting, we can. Okay, so yes.
Just a process question. So if we're taking a straw poll now and it's 5-1.
Yeah.
Then, if, again, I'm not comfortable with that at this point because I want to go through and look and be able to present arguments. But if you come back, as we had in the past, and say it was 5-1, there's no reason to reopen that. That's why I don't think it's necessary to take a straw poll at this time, except for the fact that Commissioner Fraggle is not going to be here at the next meeting. But we have another meeting scheduled for this.
I'm fine with that. I mean, we have 7 minutes, so that's fine. That's fine. And Commissioner Fraggle has already expressed her opinion, so I think we have an understanding without her being here. Commissioner Baker.
I was going to suggest we could have a straw poll, but it would be tentative, and then we could reopen and reconsider it next time, but at least that way it would give Commissioner Fraggle a chance to a little more formally express her, opinion.
And quite frankly, I don't necessarily feel strongly one way or the other, except for that I do hear what you're saying. I think it's valid, and we could take a straw poll vote to have an understanding and come back and I can honor both of you. We can come back on the next meeting on July 9th. Obviously, we'll have had time to look further into the materials, and we'll start off adding. Yes.
So I appreciate Commissioner Baker's acknowledgement of my participation in the process, but I do think that we have a process where when we take a straw poll, we don't usually come back and reopen an entire issue. And I think I feel comfortable enough stating what I took a good amount of time to go through the materials because I knew I was only going to be here tonight. And I had thought we might get to some decision making. So I just wanted to let the rest of the commission know kind of where I'm falling, that I feel like the hearings official did make a valid decision and that I support it, at least as far as what I've heard so far. I don't feel the need to take a straw poll based on the fact that I've heard several people say that they do want to dig into it more, so.
Okay. So we have 5 minutes, staff, if you have any comments. We can get into appeal issue number 2 just in terms of questions in case you have any follow-up items for staff.
I think that would be helpful because
Yeah.
what we would like to do at the next meeting is come back with a draft final order for you to respond to. You've given us, plenty of information on Appeal Issue 1 in order to do that. We will also poll you for a third meeting if that is necessary, but if we could hear a little bit about your thoughts on Appeal Issue 2, I think that would be extremely helpful.
Great, then let's do that, and I appreciate Commissioner Fraga. I would like to maintain the straw poll vote, because otherwise it unravels, so thank you for
Yeah,
that comment.
yeah, absolutely, because
And
then
also
sometimes we
trying-
do and
Yeah,
sometimes we
no,
don't.
yeah, it's good. So appeal issue number 2, are you okay moving on, or did you have a comment? No, Commissioner Ramey doesn't, you're ready for 2.
Queue for 2.
Okay, perfect.
Queue for 2.
2, so assuming the site review overlay zone does not apply to the subject properties, the hearing's official erred in denying this application, remove the overlay. So let's, Commissioner Ramey.
So I'll try to be quick and hopefully concise. I'm interested in the idea that the new Whitaker Special District changed from the old district, and that the changes, in fact, made site review unnecessary, or perhaps in the mixed-use area. So you could argue that, not that I want to argue this, just saying, one could argue that it wasn't necessary anymore because the new aspects of the new code removed some of the compatibility issues that might have been in place, or uncompatibility. So if we could just have a little bit more of your thoughts about, what do you think about that? And is that a valid argument? I didn't have time to do my homework on that piece of it. But.
Okay, perfect, thank you. Commissioner Baker.
Yeah, there's the hearings official cites this EC 9.8 Metro Plan. Again, my concern is the cascading of effects. If it's not dealt with specifically in the Metro Plan and it defers to the refinement plan, if that's the case, then you'd have to comply with the refinement plan requirements that say specifically state site review. And my second issue is the applicant brought up a design code. I didn't realize we had a design code. I know we have a zoning code, but I don't think that applies to the design of the buildings. Set certain setbacks and heights, but otherwise it doesn't provide a design code. And I just wanted clarification from staff on that. Those are my 2 issues, really.
Any other questions, follow-up items for staff? Oh, okay. So we've got a couple minutes. Staff, do you have any final comments? Otherwise, July 9th is our next meeting, and will you guys be sending out to get a tentative date for a follow-up one after that?
Yes,
Okay.
yeah, we will look for a Monday or a Tuesday that works for folks.
Okay. And will that be between, so assuming we get an email from the appellant that might, depending on availability, that could happen after July 16th?
Yeah,
Okay.
I was just looking, the 15th and the 16th are options, which means we wouldn't, at least for us, we'll have to check with everyone's schedule, but that wouldn't require any timeline extensions. And then there's some dates after that that would require timeline extensions from the applicant. But we can, based on what the poll is, we'll get an idea. The meeting on the 9th, there is a 30-minute, I think it's the Moving Ahead project. It will be here for 30 minutes, which gives you 90 minutes at that particular meeting. So it's possible you don't need the follow-up meeting. Again, it is possible that you do need a follow-up meeting, but know that you have 90 minutes. And I'd hate to not have it at that meeting, because then we just have a 30-minute Planning Commission meeting at 5:30 at night, which seems fairly inefficient.
Yeah.
So hopefully you can continue the conversation on the 9th.
Perfect. Commissioner Fraga.
And so it seems like the protocol is, if I'm not at the meeting on the 9th, but I watch the deliberations and then I am at the next meeting, it's appropriate if I participate.
Yes.
Okay, great.
Thank you. Commissioner Baker.
No, I had a question about that because we had a meeting where Commissioner Edwards was gone, but she was able to call in. So we've already had that as a precedent, just as an opportunity for, if people are away, does that open that up for other people? Commissioner Fraggle may not be available.
Yeah, I'm actually at an LCC board meeting on that night.
Yeah.
You don't want to have it.
I'm not going to call in.
No, but I'm
I
saying,
mean, I think it's an option, but it's voluntary.
yeah, no, I just mentioned it because sometimes people are traveling and away, but they could,
Yeah.
they would be able to, block out the 2-hour session to call in. So we've already established that as sort of a precedent. I guess we could consider that in the future.
In terms of an option,
Yeah.
not a precedent in terms of requirement.
No, not requiring, just as an option if people wanted to do that, yeah.
Okay. Commissioner Bobrowski.
I just wanted to end the meeting by welcoming Commissioner Beeson to the table and thank him for his willingness to serve in this capacity, and welcome to the Planning Commission.
Thank you.
So this is the
glad to be
second
here.
time that Commissioner Bobrowski's done this. It's great. I was going to close with that, and he already did it before me. He did it with Commissioner Randall, too. So thank you, and it can come from anyone. It's great. He kind of reads my mind. So it's a pleasure to have you here, and yeah, 4 years. And thank you for your commitment to the community.
Well, I'm happy to be here, so I'm going to try to spend some time listening and asking questions and get up to speed in a reasonable period.
Yeah. And I think, if you did, you can reach out. If you have procedural questions, definitely talk to staff. And then obviously commissioners, as long as there isn't a quorum. So if you're meeting with a commissioner, just make sure another two don't sit down with you.
All right, good.
Yeah.
Okay, thank you very much.
Just learn how to drink out of a fire hose, right?
That's right. That's right. So welcome. Thank you. Thank you. Well, you're awesome. It's like, oh, yeah. Oh, gavel.